necessary to have confidentiality in communications and deliberations in order to have good and worthwhile deliberations, in order to have people provide their candid advice to the president. Because if they knew what they were going to say was going to be on the front page of the Washington Post the next day or the next week, they wouldn't tell the president what they actually thought. If you want to have good decision-making, there has to be that zone of confidentiality. And this is the way the Supreme Court put it. Quote, "Human experience teaches that those who expect public dissemination of their remarks may well temper candor with a concern for appearances and for their own interests to the detriment of the decision-making process." End quote. That was also from United States versus Nixon. So those are exactly the interests that are protected by having senior advisors to the president be immune from compelled congressional testimony. Because once someone is compelled to sit in the witness seat and start answering questions, it's very hard for them to protect that privilege, to make sure that they don't start revealing something that was discussed. So for a small circle of those close to the president, for the past 40 to 50 years, administrations of both parties have insisted on this principle. Now, the other night, the House managers, when we were here very late last week, they suggested that executive privilege was a distraction, and Manager Nadler called it nonsense. Not at all. It is a principle recognized by the Supreme Court, a constitutional principle grounded in the separation of powers. They also asserted that this immunity has been rejected by every court that has addressed it, as if to make it seem that lots of courts have addressed this. They've all said that this theory just doesn't fly. That's not accurate. That's not true. In fact, in most instances, once the president asserts immunity for a senior advisor, the accommodations process between the executive branch and the legislature begins, and there's usually some compromise to allow perhaps some testimony, not in an open hearing, but in a closed hearing or in a deposition, perhaps to provide some other information instead of live testimony. There's a compromise. But the only two times it's been litigated, district courts, it is true, rejected the immunity. One was in a case involving former counsel to President George W. Bush, Harriet Miers. The district court rejected the immunity, but immediately on appeal, the Court of Appeals for the D.C. Circuit stayed that decision. And that decision means to stay that district court decision, that the appellate court thought there was a likelihood of success on appeal, that the executive branch might succeed, or at a minimum, that the issue of immunity presented questions going to the merits so serious, substantial, difficult, and doubtful as to make them a fair ground for litigation. So the first decision was stayed. The second district court decision is still being litigated right now. It's the McGahn case that the House has brought, trying to get testimony from former counsel to President Trump, Donald McGahn. And that case was just argued in the D.C. Circuit on January 3rd. So there is no established law suggesting that this immunity somehow has been rejected by the courts. It's still being litigated right now. And it is an immunity that is a standard principle asserted by every administration of both parties for the past 40 years. Asserting that principle can't be treated as obstruction of Congress. The third action that the president took, that the administration took, related to the fact that House Democrats' subpoenas tried to shut out executive branch counsel, agency counsel, from the depositions of executive branch employees. Now, the Office of Legal Counsel concluded that congressional committees may not bar agency counsel from assisting an executive branch witness without contravening the legitimate prerogatives of the executive branch, and that attempting to enforce a subpoena while barring agency counsel, quote, would be unconstitutional, unquote. The president relied on that legal advice here. As Judge Starr pointed out, the president was consulting with the Department of Justice, receiving advice from the very respected Office of Legal Counsel, and following that advice about the constitutional prerogatives of his office and the constitutional prerogatives of the executive branch. Again, administrations of both political parties have recognized the important role that agency counsel plays. In the Obama administration, the Office of Legal Counsel stated that exclusion of agency counsel, quote, could potentially undermine the president's constitutional authority to consider and assert executive privilege where appropriate. So why is agency counsel important? As I tried to explain, the executive privilege of confidentiality for communications with the president, for internal deliberative communications of the executive branch, those are important legal rights. They're necessary for the proper functioning of the executive branch. And agency counsel is essential to protect those legal rights. When an individual employee goes in to testify, he or she might not know, probably would not know, where is the line for what's covered by executive privilege or deliberative process privilege? Not things that employees necessarily know. And their personal counsel, even if they're permitted to have their personal counsel with them, same thing. Most attorneys for employees don't know the finer points of executive branch confidentiality interests, of deliberative process privilege, and it's also not their job to protect those interests. They're the personal lawyer for the employee who's testifying, trying to protect that employee from potential legal consequences. We usually have lawyers to protect legal rights. So it makes sense when there is an important legal and constitutionally based right at stake, the executive privilege, that there should be a lawyer there to protect that right for the executive branch. And that's the principle that the Office of Legal Counsel endorsed. This also doesn't raise any insurmountable problems for congressional investigations or finding information. In fact, just as recently as April 2019, the House Committee on Oversight and Government Reform reached an accommodation with the Trump administration after the administration had declined to make someone available for a deposition because of the lack of agency counsel. And that issue was worked out, an accommodation was made, and there was some testimony provided in other circumstances. So it doesn't always result in the kind of escalation that was seen here straight to impeachment. The accommodation process can work things out. House Democrats have pointed to a House rule that excludes agency counsel, but